So without further ado, Angela Davis, partner of Gerard and Davis, who does ACCG's work or employee helpline and other things, is going to talk about social media. So take it away, Angela.
Okay, well, good morning, everybody. And of course, Dan, that 0.1% is really going to ruin my day. So I wish you hadn't told me that. But I will strive to capture everyone today and hope that everyone will enjoy this presentation. As I was telling Dan in the beginning, I apologize for some of my technical difficulties to get started. I have a new laptop and I don't do good with new technology, and everything was looking different. But bear with me and hopefully we will get through this just fine.
Hey,
So
Angela,
today,
just before you go, one, that was a joke. So there was no,
yeah, oh, okay. I thought it was
make,
technical data.
there's no actual data. That was all, that was just my hyperbole. And a comment here, I think Angela's the best presenter you have ever had. Keep her. And I would agree with that.
Oh, who is that sweet dear person? I can't see the chat, so I'm gonna need that name later.
I'll send that to you later, but I think you'll have many fans after. But go ahead.
Thank you so much. I'm going to be reluctant to click buttons to try to see the chat because every time I touch something, I mess it up. So Dan, if you would feel free to hop in and let me know because I'm not seeing those comments. But it is apropos, I guess, that we are doing social media and technology talks today when I'm struggling like I am. But again, bear with me and I'll enjoy the next few minutes we have together today to talk about social media. I talk about social media every day, and at times I feel like every hour, and largely that's because I have a teenage daughter who I'm constantly saying, get off your phone, get off your social media. I don't even understand all the things that kids do today with snapping and TikToking and chatting and the gram and all that. I know enough to say stop it, but don't know a ton about how everything operates. And if you have a teenage daughter or teenage son or kids generally, I'm sure you may deal with social media all the time, all day, every day, like I do. But not only is it in our home and with our kids, it's increasingly an issue that's in the workplace to the point that we really just can't deny anymore the level at which social media is permeating not only our kids' lives, but our adult lives, and then our workplaces as well. And so that's a challenge for us. Assuming many of you are either HR directors or have some other kind of administrative role or leadership role with your government entities, this is something that we really have got to get a handle on and be prepared to address because it's not going away. It's becoming a bigger and bigger issue. So today, in an effort to try to tackle these topics for you in a way that I hope will be meaningful and useful, I'm going to talk about four big subject matters. First, we're going to break it down categorically to dealing with employees and employee use of social media. And invariably, that may then mean how do you discipline an employee? How do you decide if you can discipline an employee for use of social media? Included in that, we'll be talking about social media policy provisions. And then the other big issue that we deal with as government entities is managing our own government social media sites. So I'm also going to talk about that and some traps to be aware of and some policy and provisions that we need there to protect our government websites. And then we're going to talk about blocking users because as soon as you have a site, you may have a need to block a user. I get those questions all the time, and there's some stumbling blocks there that I want to make sure that you can avoid. All right, now without me touching anything, my PowerPoint just went away. I don't know how to explain that. Let me see if I can get it back. Everybody just...
You can see right now, Angela, you can see roadmaps. So the slide that says roadmaps, it's showing there, but now it's not.
Okay, that's odd. It just went away from me. Okay. Oh my goodness. All right, y'all, this is really bad. I apologize. All right, it's there now. Okay. So the third component is blocking users that we'll talk about. And then the final piece I want to talk about is something that's maybe not as intuitive, and that is consideration of Title VII and equal protection and how that might be related to use of social media and disciplinary issues related to that. So let's just jump right in and take the first big issue, and that's our employees and how they use social media and how we can deal with that. So I wish we were all in a room together and I could ask this question and see your hands and hear you yell out your answers, but I think this is an easy question. What is the #1 legal issue that you believe we have to deal with when it comes to using social media? You put that in the chat. Dan, if you see any answers, you'd be happy to shout them out to me. But the one big legal issue when we're talking about social media, what do we have to be wary of?
I got
Since
one. I
okay,
have one. It says defamation, freedom of speech.
those are great answers. Great answers. Both actually absolutely true. And I'm going to start with the First Amendment because that is the big issue that we have to be wary of when we are trying to control how our employees use social media. So, and this is a unique challenge for public employers. So if you have a friend who's an HR manager or a business owner of a private business, maybe they're the HR director for Publix or Home Depot or, Joe's Supply Company, they don't have the same problems that we have. As a public employer, you are an arm of the government, even when dealing with our employees. And so we do have to consider violating someone's First Amendment rights and also other constitutional rights when it comes to how we deal with their speech. And of course, social media is a speech issue. Now, I want to share this case with you to start with because this really emphasizes just the level at which social media has risen in our country and the significance that it has in this world of free speech. So back in the days that our founding fathers wrote the Constitution and came up with the First Amendment and the right to freedom of speech, sort of the quintessential notion was the town crier who might stand on a soapbox in the town square and be free to speak openly about issues to the town. And so that soapbox kind of speech is where much of the First Amendment jurisprudence comes from. Well, today we have all kinds of different opportunities for those speech discourse opportunities. Probably none of the kind of things that the framers of our Constitution would have thought of back in those days. But we've really emerged beyond television and beyond newspapers to this social media and all these digital platforms. Well, this case is interesting. It came out of North Carolina, and there was a North Carolina criminal statute that made it a felony for any registered sex offender to be able to access a number of websites, but also including the digital platforms of Facebook and Twitter. And the United States Supreme Court ruled that statute unconstitutional because the court found that even this convicted sex offender who's registered, that they had a right, not only of freedom of speech, but a freedom to access these social media sites. So that's an important jump, I think, that not only do you have the right to speak, but you have the right to access, interact, and participate on social media sites protected by the First Amendment. And here's what the court said. The court equated social media to speaking and listening in the modern public square as a town crier with a voice that resonates further than it could from any soapbox. And that really is true. Social media is where many of us get our news and our information, and it's a critical aspect of public discourse in today's age. But I wanted to start with that case just to show that even the Supreme Court is recognizing the significance of social media platforms. Now, for those of us in the workplace and dealing with these issues, I call it a crisis. I really believe we're in a social media crisis. I'm getting calls all the time, every day, from clients because we have employees, I think, just kind of being in a frenzy about their posts. And I mean, just the world at large, I think that's the case. We're living with all of these things going on, a global pandemic. We've got protests, we've got racial tension, we've got economic disruptions, a vaccine debate that continues. We have a divisive presidential election we just came out of and the continued discussions about that and about election reform. All of these really big global issues, I think, are provoking more and more social media posts to the point that I think there's this frenzied pace of posting. Essentially, it's a crisis for us and how to deal with it. And I think that's why in a couple years ago, you may have had one or two issues like this come up, and then now you may be having them almost every day where you're getting reports of employees who are posting things that offend somebody or that crosses a line with respect to some of these big global issues. So I want to start with just a few newspaper articles and situations to show you what I'm seeing and hearing in terms of employee issues. I hope you haven't had all these issues, but if you haven't yet, you probably will. So let's take a look at a few just to get a snapshot of the issues that you could deal with in the employee context. So this first report here, and by the way, Dan will send out this PowerPoint to everyone, and so you'll have these live links if you're interested in clicking in and reading these stories. Some of them are pretty interesting. But this was in Tallapoosa. It was a police sergeant, and he made a post that I've kind of tried to put there at the display. that was just anti-protester, really kind of making light of or coming out against anyone protesting, looting, and making comments about those things. So this police sergeant posts, it comes to the attention of his police chief and to the city. And what do you think the result would be? If you want to put in the chat, let me know. Do you think he should be disciplined? Do you think you can discipline as a matter of law, or do you think he would be sued if you discipline because he made this post? Obviously, he did it off hours. In this post, you don't see anything where he is connecting himself necessarily to this police department. So what do you think? Can he be fired? Should he not be fired? Should he be disciplined at all? Well, the result here was he was fired. And I think it was appropriate. I think it could be appropriate. And we'll talk more about what the tests are. But before we get into those First Amendment tests, I just want you to get a feel for some of the fact patterns. So here's another one. Again, it's a police officer. He's part-time. He makes a Facebook post that calls for hanging of some individuals in the community, obviously creates some racial tension. And his result, again, he's fired for that. Here's one more. This is a Georgia police officer. He posts on Facebook. Now, this one may seem a little bit more benign. He talks about privilege and what privilege means to him versus, I think, some of the allegations of what privilege means to others. And you can see part of the post there in the display. It sparked controversy. And while it's maybe not on his face as blatant as the first two we saw, what do you think? Should he be disciplined? How would you handle that if it's coming across your desk and you're asked to give an opinion? Well, in this instance, he was fired as well. Here's another. In Roswell, city of Roswell, suburb of Atlanta, a 911 communication officer posts what you see there, a Confederate flag. It was deemed to be racially charged, and there were some complaints about it. Again, if that comes across your desk, how do you deal with it? I know you hope it doesn't come across your desk because these are tough issues. This individual was fired as well. So how do we decide whether we can fire, whether we can do something and should do something of a lesser disciplinary measure, or whether we can't touch them because it's First Amendment protected? It's not easy. And as much as I'd like to say there's a clear, bright line test, there is a test, and I'm going to teach you that test. But it's also something that you have to deal with on a case-by-case basis. And I also think it matters very much what employee we're talking about and what position they hold. And we'll talk about that a little more in just a minute. But there's essentially a two-part test to decide if this is First Amendment protected speech that you need to be very careful about disciplining on. So the first question you have to ask is, did the employee speak out as a citizen on a matter of public concern, as opposed to speaking out as an employee in relation to some kind of personal grievance about his personal employment? So if it's an employee speaking about work, and in order for that to be deemed a matter of public concern, then that speech has to be uttered in a way that there's some kind of call to action, call for reform, call to improve public welfare, not just to benefit his situation. So sort of an example there. If you have an employee who's speaking out on vaccines, then that is largely going to be probably deemed public concern speech and protected by the First Amendment, unless we get to step 2, and I'll show you that in a second. Then unless step 2 leads us in a different direction. But if that same employee happens to work for the county and has been required to have a vaccine, or there's a consideration of a disciplinary action because of something he's done with respect to the vaccine, and he's speaking out against his employer on that limited point, then arguably that could be closer and more akin to him speaking as to a personal grievance instead of just a matter of a public concern or a general public issue. So again, even in that example, you can see how close and how difficult those conversations and discussions and decisions can be. When you're looking at trying to decide if it's a matter of public concern on this first part of the test, a court's going to look at the content of the speech, the form the speech comes in, and also the context. And here's some of the main questions that'll guide you as you're trying to look at these issues. Was the main thrust of the speech essentially public in nature, or was it private? So if someone's posting on a Facebook page, or maybe they're even coming and they're speaking at your public meeting, or they're putting it on Instagram, or even posting it as a comment on your own government website, then that would seem to be very public in nature. If it's an individual email, if it's individual directed Facebook private message, then it might seem to be more private, and that might lead you more to it being an employee communication as opposed to a public concern communication. Next question you might ask, and similarly situated as to the first, is was it communicated to the public at large, or was it private and maintained privately to an individual? And then finally, what was the speaker's motivation? Is the speaker talking about an issue because they want to invoke change and concern about a topic of social importance or legal importance or public importance, or is that person's motivation simply to improve their situation? Like they're complaining because they want a raise, as opposed to they're complaining about some kind of more global issue in their workplace. So if you decide after you've gone through these questions and looked at the content, context, and motivation of the speech that it's not speech of a public concern, if that's the case, then there's no First Amendment protection, and then you can discipline as you see fit. One really good example here is, if someone has a Facebook post and they're just ragging on their supervisor. I have the worst supervisor. He was horrible. He said this today and he's rotten and I hate him and, blah, blah, blah. Well, I would say that's probably not public concern. It looks like a personal vendetta against the supervisor. Once you've determined there's not First Amendment protection, then you can discipline that employee for insubordination or for anything else that you think might give rise to a disciplinary action under your policies. But if you decide that it is a matter of public concern, that this employee appears to be speaking out in a public forum on issues that are in the public domain, and in today's world, that could be vaccines, it could be the presidential issues, it could be social justice, it could be racial tensions, any of those things. If it's public concern, then you do have to worry about the First Amendment, and that's where step 2 comes in, and that's to do a balancing test. So our step 2 on our First Amendment test is we have to balance the employees. Do you have a question?
I do. So
okay,
this is the question. This is interesting. Do these questions test still apply to employees that have private social media accounts?
That's interesting. Well, it's all about what does private mean, right? So anybody's Facebook page likely has some private controls on it, that you only have people who are your friends, quote unquote, in your Facebook account. I still would deem that public because there are a lot of people that are hearing that. I would distinguish that from if you send a direct message to an individual person. I think then you might have to worry about such things as defamation or something else, but that wouldn't be a public discourse. But I think when you engage in Facebook, even when it's among a subset of your friends, which may not mean everybody in the world can see it, but it's still a large group of public individuals, and I would consider that to be a public discourse, a public post. Kind of like the idea, if you go back to the Old Town Crier, I mean, he's standing on the corner, but he may only be speaking to his neighbors because those are the only people who are around, but that doesn't make it any less public just because the whole world is unable to see it. So I hope that helps on that point. So if you decide that it is public and you go to step 2, then you have to balance. And this is where it gets even more mushier, if you will, in terms of trying to decide if it's a violation or not, a violation of the First Amendment. But the test here is that you balance the employee's interest in commenting on a matter of public concern, so their interest in First Amendment protection, against the government's interest in being able to provide public services efficiently and effectively. When you're looking at the employer's interest as the government, you're going to consider such things as, does that speech contravene the ability to promote loyalty, to promote morale? Does it create a lack of disruption? Does it cause harmony issues in the workplace? Does it create a distrust, perhaps, in the community for the person who does this job? Those are the kind of things in a balancing test that you'll be looking at. So if an employee's interest is deemed to outweigh the government interest, so we say the employee's interest in speaking outweighs any interest that the government can articulate as their public interest for how they run their workplace, then the employee is going to state a First Amendment claim. And then if we discipline that employee, we could be subject to a case alleging a violation of the First Amendment. Now, when you're looking at these issues, the government's interest can be many, many things, and we'll talk about that a little bit more. But I want you to know off the top that the government's interest is particularly strong in the context of law enforcement and other departments that are more like a quasi-military organization, because the courts have routinely recognized the need to maintain discipline and morale, uniformity, and trust in the ranks. Also trust within the community. So that's why, if you remember those posts that I showed you in the beginning, all of those were police officers and all of them were fired. Had those same posts been done by someone who was an administrative assistant in the tax department, might not have been the same governmental interest. But when you've got a police officer who is calling people to arms or saying things like it's a second revolution, well, knowing that this is someone who's armed and out in the community to protect the community, then that could be a strong government interest to say, okay, this is going to create potentially more unrest in the community based upon your post, and creates a mistrust of our organization that we're here to protect all people. So those are the kind of considerations that'll be in play, but that's why the government interest for law enforcement and other related organizations are typically much stronger, and that's where you're going to see most of the disciplinary actions that are going to be supported and not be deemed to violate the First Amendment. I put a couple of cases here just because I think the quotes are helpful with respect to understanding this. So in fact, let me read this one to you. It's affording public employers a greater latitude to burden an employee's rights of speech, is what they're talking about, particularly when the exercise of that right impacts discipline, morale, harmony, uniformity, and trust in the ranks. Here are some other cases that I wanted to share with you, and when you get these materials, you can read through them in more detail. But again, examples of how this balancing happens. So the first case, all of these are within our judicial district, the 11th Circuit. In the McCullers case that they're first, this one I wanted to highlight because it's a clerk's office employee. So it's not your typical law enforcement employee, but the clerk's office employee posted something about an African-American female state attorney. And so that, while it's not a law enforcement person, it's a clerk posting about someone who is an attorney, a state attorney, the U.S. Attorney's Office, who would be interacting in that court and be a part of the exchange of information and day-to-day interactions. And so I think that connectivity made it ever more important here that the government was able to show that they had a substantial state interest when this post was inappropriate, alleging that the state attorney should get the death penalty and should be tarred and feathered because they did not see, in this clerk's opinion, enough of a stringent sentence for someone coming before their court. So again, it's a case-by-case analysis, and it really matters a lot about who the employee is, what the position is, and then how that speech correlates. So in that vaccine example that I gave earlier, if you have someone in your health department who's charged with giving out vaccines and they're posting, and their posts are anti-vaccine and suggesting all the negative reactions about vaccines, well, when that is their direct job to provide those vaccines and to instill trust in the community in terms of how they're performing their duties, then that would be something that potentially would be a balancing that would weigh in favor of the government interest and against the employee's First Amendment interest. So you see how it matters what the position is and how it correlates to the speech. Again, there's a couple more examples here of law enforcement and calling people to arms for a revolution. That, again, relates much more closely to the trust in the community, safety in the community, not wanting to create uprising and protests when these law enforcement officers are there to attempt to keep the peace. So those are the basic issues with respect to how we discipline employees. Now, I've told you a test, and the test sounds simple, right? Is it a matter of public concern? And if it is, then you do a balancing test, and you balance the government interest against the employee interest. Sounds super simple, right? Well, it's not, for all the reasons that I'm sure you know, and I've said, it really can be quite a difficult decision, and it has to be made on a case-by-case basis. And honestly, I would suggest you consult with counsel because it can be difficult to make these decisions, but you can look at some of the existing cases to support as to what is speech that goes across the line. And also you can be sure to look at how it's been balanced by other courts and other jurisdictions in making your decisions. But hopefully that gives you some idea of how you can go about disciplining these employees if you have speech issues brought to your attention. Now, I will suggest this to you before we go into the policy. These are issues, and I've had a client ask me this before, you know, gosh, I don't know what I don't know. What if people are posting all these things out there and I don't know about it? That's right. You don't know what you don't know. So you have to take it on a complaint basis. But if it's brought to your attention, then you need to deal with it. And if it's brought to your attention and you deal with Joe and Sam's doing the same thing, but you never knew Sam did it, well, then you don't know what you don't know. But be sure that you're doing any kind of disciplinary actions in a consistent manner. And we'll talk about that a little bit more at the end of the presentation. I'm going to shift gears now quickly into the social media policy aspects. What I've endeavored to do here is to provide you with what I believe are some key points that you might want to have in your social media policy. So my hope is when you get this presentation that Dan will email out to you, you can take your own social media policy and you can just kind of do some check marks. You know, do I cover these things? Do I need to add some of these provisions? And hopefully that will help you in getting your own policy up to date and workable. What I think is important is to sort of think of 3 rules of engagement that are the overriding guiding points for any social media policy. And that is disclose, protect, and use common sense. So by disclosure, what I mean by that is I think your policy should address issues related to disclosing by the employee that his views are that of an individual and that he's not holding himself out as a representative of the employer. Social media in terms of your Facebook page or an Instagram page or any time that you may post, I think it's important that there's a transparency that you're identifying yourself as an individual. And I'll show you some policy provisions that go directly to that. Another overriding rule of engagement, I think, in your policy should be protecting. You need to have policy provisions that are going to be geared to protecting your employee, but most importantly, to protect the government from any belief that there's some kind of affiliation with these posts that you have no control over. And then your policy provisions, as a third overriding rule of engagement, need to make sure that they are common sense driven. And that's what you need to really try to instill in your employees. Use common sense in your social media posts. You know, it may seem unfair sometimes because these employees, you know, they may say friends who are working over at McDonald's or working, you know, for private companies that don't have these same interests. But because we are a governmental employee, it is important to think about image and reputation and how that may be portrayed onto the government and create issues with the community and community trust. So common sense is key in any of the provisions that you have in your policy. So let's just run through a few of these policies that I would suggest that you consider including. Maybe not word for word, I'm just trying to give you some kind of categorical issues that I think are important for your social media policy. I think it's important to suggest to your employees that they have a first person disclaimer, that they write in first person, that they're writing on behalf of themselves and not suggesting that they're writing on behalf of the employer. You know, if it's just your rank and file employee, that's kind of easy. But if you have a director of engineering or if you have a commissioner, I mean, some of my biggest issues, honestly, have been with elected officials who engage in a lot of governmental discourse on their private social media sites. And it brings a level of discomfort because there's a belief that that's speaking on behalf of the county or the city when that's not the case. So I think it's important to encourage not only your employees, but your elected officials to write in first person, to not attach a title to their name. And in fact, ideally, you would have in your policy a request. I don't know that you could mandate this, but I think a request and a recommendation that a government employee's post sites like Facebook or Instagram might have a disclaimer saying the posts on this site are my own and do not necessarily represent the position, strategy, or opinions of my county or city or whatever governmental entity it is. Now, I don't think we necessarily can mandate an employee to do that, but I think you could ask them to do it. And if they do it, then I think that helps in a disciplinary matter to remediate perhaps some of the statements that they may make. Okay, can everyone still hear me? Dan, can you hear me?
Yes, we hear you loud and clear. You're doing great.
I got it. Okay, I have a pop-up saying slow network connection, so just want to make sure. It continues.
Everybody's saying yes at this point in time. So
okay, great. Okay, now of course I just clicked something to fix that, and I lost my PowerPoint. Oh my goodness. I tell you what, I'm not going to get 99% today. I apologize, everybody. Hold on just a second here. I think I'm going to okay, there we go. Okay. So next point is really important on your social media policy provisions that you preclude employees and tell them that they can't use local government information on their sites. They can't put up their local government email or addresses or passwords. So if you've got an employee with a Facebook page, they don't need to have that connected to their government email, and you can preclude that. You should tell your employees in their policies that they need to avoid using government's names, logos, images, graphics, all of those types of things that connect them to their employer on their private social media pages. You know, sort of the quintessential thing that we don't want to see is their social media profile picture being in their uniform. That happens a lot. But then when it is, it's identifying it directly to that police chief, police force, to the sheriff's office, or even if it's just someone in their uniform that has a county logo on their shirt, or they have the badge hanging around their neck and they can be identified with that government employer, then everything they post on that site seems connected and potentially the views of the government, and that's what you want to avoid. So having a policy that says don't do those things, don't use your profile picture in your uniform, those are things I think you can prohibit, and I would suggest strongly that you do. And then also, may seem obvious, but putting these rules in a policy I think are important, because sometimes it's not obvious to employees, but employees cannot link to personal social media sites from their local government site. So if you have a web page for your water department and all the employees are there and maybe have little blogs or their government email addresses on that web page, they can't link also to their personal pages. That would be a good rule to have. Having a policy provision in your social media site that requires confidentiality is also important. Again, should seem obvious, but you want to require that your employees act responsibly with trusted confidential information, that they refrain from commenting on pending legal matters, and that they preserve attorney-client communications. I have been horrified in litigation before to have a Facebook post put in front of me and see that an employee, and sometimes an elected official, has posted something where they're talking about a pending legal case, or even in one instance, even legal advice that's been given in that pending legal case, and they posted it up on their Facebook page. Those are the kind of things that really can compromise the county's ability to protect that confidential information. So have a rule so that there's no question in your policy that employees are prohibited from such things. I think it's also good to have a rule in your policy that makes it clear that the employee has personal responsibility. If you're going to post, then you're responsible for it. And you have to be responsible for respecting your audience. I would have a provision, as I show in bullet point 2, that suggests that your personal social media has respect for audience in terms of refraining from ethnic slurs, personal insults, obscenity, all of the things that would be offensive, inflammatory, because it could be a portrayal in of your affiliation with the government. Also, I think your policy could and should caution employees about how they do such things as liking, sharing, retweeting, or linking to posts. Sometimes I think that feels like you can kind of hide in a closet and do it if you're just liking or you're just retweeting or sharing. But that's the same as posting that material, and so they should be cautioned about that in your policy as well. Also in your social media policy, I think it's good for you to say that employees should continue workplace appropriate communications. Now, it's hard to govern this, and it's hard to manage this sometimes, but I think having a policy that makes employees think about it hopefully will conform some of their conduct, even if it doesn't make it completely compliant. So I would have a policy that asks for workplace appropriate conduct on their posts, meaning that they have to be consistent with how they would present themselves to citizens and coworkers on the job, and that they use diligence to show that it's their personal site and not an affiliated government site. But think about this, and this is how I think you can explain it to your employees, and this is why such a policy is important. If you have someone who's a frontline employee, maybe it's your planning director who's working with developers and citizens every day, people coming in and out of his office. And if that's someone who's posting things that are consistently offensive and kind of outrageous and demeaning, maybe to one gender or demeaning to a race or whatever it may be, then for the people who are coming in to communicate with that person and seek their help on a daily basis, that makes those communications and the ability of the community and the ability of the county to count on that director or that employee interacting with the community really be compromised and in a point of concern. So those are the kind of things that we're worrying about. It could be completely unrelated to work, but it could create an appearance of that employee not being someone that's going to be open to working with people of all types and kinds in the community. So having some kind of workplace appropriate policy urging that kind of conduct, I think, is important. This is critical. You should have in your social media policy a requirement that the employee cannot hold themselves out as a representative of the county. So their social media site does not need to appear to be official. Again, that's where I think a profile picture, if you got a profile picture in your sheriff's uniform and you're posting stuff, that sure looks official. So they can't do it. They shouldn't do it, and that should be a disciplinary matter. Avoid using reference to your position. As the director of planning, I'm urging you to oppose this rezoning in our neighborhood. That would be entirely inappropriate for all the obvious reasons. And also, I think it goes as far as posting photographs at the workplace, posting photographs in uniforms, and even posting photographs that show visible employee badges or like t-shirts with logos. Now, certainly people are going to post pictures like that from time to time because they're showing their life experiences. So if they're at a retirement party, you may see a big group of police officers together celebrating a retirement. I'm not suggesting that's completely inappropriate or that would be one of your firing situations, but I would suggest that they avoid doing that to the extent that when they do, then anything they say on that site, once they've connected it to their government employment, is going to be more subject to discipline because of that affiliation that they've created. So the more private an employee keeps their Facebook and social media sites, the more then that you need to be less concerned about what they are posting. A social media policy that says that they're expected to follow the law with any social media post is certainly appropriate. No sexually explicit materials, no violations of copy law. So that's an easy one to follow. Now I'm going to go through a few very basic provisions that I think you could really just drop down into your policy. I think it's important to recognize in your social media policy, sort of as a preface to your policy, that you are aware of the First Amendment and you're intending to comply with the First Amendment. So what I have here is a statement that you're mindful that these are private citizens with legitimate interests in matters of public concern, and you really basically set out that test that I told you about, so that employees know that you're going to work within the First Amendment and you're intending to respect the First Amendment, but that there is somewhat of a limit because of the governmental position that they hold. The reason something like this is good to have in your policy is because if we do discipline an employee and then we get that lawsuit that we violated the First Amendment, it's helpful in any kind of defense of those actions to be able to show in your policy that this policy was drafted and implemented and applied and enforced, all with an eye towards compliance with the First Amendment. Here is a policy that I'm throwing. Oh, go ahead.
I have a question here, and it might have been from a couple slides back. What about spouses, family members that comment on government matters? Could be of an employee or an elected official.
That is a wonderful question. I've had that very thing happen before, where there was a wife, a very vocal wife of a police chief, and it was causing all kinds of disruption within the organization. So obviously we cannot directly discipline that wife, but it was something that we ended up dealing with the police chief on to try to ask him to conform that conduct because it was creating such a disruption. So we couldn't really, we didn't discipline the employee, but we did have a counseling and encourage him to get that under control. And it worked, and it resolved itself. If it didn't work, then I think that gets to be a really difficult situation because I don't think we can control, obviously, a non-employee. So what I've put up here, and I'm not going to read through it. I see we already amazingly get pushed for time. But again, I wanted you just to have these policy points that you can just use as a checklist with your own policies. But this is a policy from an Arizona Police Department. And the reason I'm sharing it with you is because it was specifically upheld by a court. And you don't get the luxury many times of finding a policy that's dumped into a case, and you can see exactly what the court upheld. But this slide and the next one continues here, showing what this particular social media policy was in the city of Arizona's police department that was upheld by this district court. You'll see many of the things that I've just talked you through, so I just wanted you to see that as an example of kind of pulling some of those points together. Now I'm going to shift gears real quickly. So you know how to discipline an employee, you've got some checkpoints on how to develop your social media policy. And then now as a government, I'm assuming you have a Facebook page or you have a website or maybe even an Instagram or a Twitter. I think a lot of governments are becoming extremely social media inclined, and it's a great way to get the word out on things you're doing. So much for the old cable broadcast when you had, your meetings broadcast on cable television, and that was the only way you really were reaching the community with your direct message. Now there's a lot more ways to do that. But with having the development over social media sites for the governments, it raises all kinds of new issues that we have to struggle with. So what I think is important as a first matter is if you have a Facebook page or an Instagram or anything like that, I think it's important that you have an internal policy that's very clear about who has account and content management authorizations. So this internal policy for running your social media sites should include the government stated purpose. So what is the site about? Do you have a Facebook page for the government so that people can submit complaints or submit, requests for potholes to be filled? Or is it simply for, discourse? Is it going to be an interactive site, or is it going to be simply the government putting out its information? But in that internal policy, you need to sort of have a mission statement of what the goal is for that social media site. And then you need to be very clear on who's authorized to create social media accounts, and then who has the oversight for monitoring those sites. Also, here's a few other things. I don't have to read them all to you, but I want you to take a look at them once you get the materials. You need to identify who's got the authority to post and change content, who's going to be responsible for fact checking. You need guidelines for how you're going to handle or not handle comments. And that's a huge point when we get to talking about blocking users in just a minute. You can decide. I think there's settings on all of these social media sites that just does not accept comments. And you may want to go that route. That's a safe way to go because then you don't have to worry about those comments that you get and you want to block. But you need to develop what is your internal rules and guidelines for what you're going to do on these social media sites. And also, don't forget that because this is a social media site for a government, it's still subject to document retention and compliance with the Georgia Open Records Act. So if you get an Open Records Act request and they're asking for all records related to XYZ, and you posted on your Facebook page about XYZ, that's a responsive record that you need to worry about producing, and also that you need to worry about retaining consistent with the Secretary of State's retention rules. So a lot to think about when you have these social media sites. I have had issues come up time and again where a county or a city has a social media site. They don't have clear rules about what can be posted, and then I have an elected official who gets very upset because they think something's posted that was inappropriate, or some employee who wasn't intended to post somehow has access and makes a post. So these are things that are much better handled with an internal policy on the front end than waiting until something goes wrong on the back end and you receive issues or complaints. So in addition to having that internal policy about how you're going to work it with your employees who are managing your site, you also want to have a terms of use policy. So if anyone's ever gone into Twitter or Facebook and clicked their terms of use, it is a lengthy boilerplate document that talks about what you're agreeing to when you access their site. So that's what I'm talking about when I say terms of use. So if you haven't thought through that issue, it's really, in essence, thinking about all the disclaimers that you want on your site to protect the government from those people who are going to come on and use and view and interact with your social media platforms. I'm going to run through a few issues here that I think you need to include in your terms of use, and I'll be mindful of our time. But again, you've got them here in your written materials. Again, I think it's important to describe the purpose of the site in your terms of use. And I found it helpful to disclose the hours that it will be monitored so that people have an understanding of when they might receive and expect a response if indeed you're going to have an interactive site. So many local governments at this point are using Facebook pages for people to submit Open Records Act requests, to submit street maintenance requests like pothole requests, or to identify other complaints like property management complaints. If you're doing something like that, then I do think it's important to disclose hours so that a person, when they submit it, they realize, okay, if I submitted this at 12 o'clock at night, I'm likely not going to hear from anybody the next day. That way, if it's an emergency, if someone's trying to report something to your marshal's office through your social media site, and it's really an emergency, then they need to be on notice that they need to do that through 911 or something else besides your social media site. You'll be amazed at people who will submit things and expect they're supposed to get an immediate answer and then complain or contend some kind of liability because they did not. I think it's important as a terms of use that you designate all local government social media accounts as a limited public forum. We talked about the concept of, what's an issue of going public concern when you're speaking. Well, not only is there issue of what is the speech, but also where are you speaking? What is the platform? What is the venue? What is the forum? And under First Amendment law, you have something called a public forum, which is like out on the streets, speaking, on the town square, on the soapbox, and then something that's called a limited public forum. Your commission meetings, your council meetings, I would call that a limited public forum because you have rules of decorum and rules of procedure such that people can't just stand up and start speaking or yelling out their issues. They have to kind of play by the rules. That's what a limited public forum is. They're constrained to express opinions, but within the context of rules that govern the conduct, and also keeping to topics that are in play on that particular site. So this is just a terms of use protection if you designate yourself as a limited public forum. Here's another element that I would include in a terms of use policy, that any comments are the opinions of the user and not the local government. A lot of people, if you have an interactive site, you may post something that's controversial on your Facebook page, and then sometimes it's the comments that get going and they get really concerning, and sometimes can even involve in where you think if they were in the same room, there'd be a fist fight with these comments back and forth. So I think it's important to say the comments are not part of your social media message from the government, and it's not your opinion, it's the opinions of those individual users. Here are a few more points that I think are important disclosures to be in a term of use. And I'm going to keep rocking through these because we're running short on time. Here is a very important thing, I think, to have in a terms of use or somewhere on your social media site, and that is a criteria for removal of comments. In just a minute, we're going to talk about blocking comments, but in order to block comments, I think it's very important that you set up this criteria for how and why you would block comments or remove public comments. Now, again, if you have a social media site and you've decided it's not available for comments and it's not interactive, nobody can comment, nobody can post onto it from the public, you've saved yourself a lot of trouble. A lot of people enjoy the interactive, but if you don't allow for that, then you don't have to worry about this and you don't have to worry about blocking. But most Facebook pages I see do allow for interactive comments to be made. And a lot of times that's exactly how the government keeps their finger on the pulse and takes the temperature of the community on a variety of issues. It's almost like an ultimate public hearing, if you will, because they can hear what people are thinking. So more times than not, I see comments being allowed. And if you do that, I would suggest strongly that you have a statement on your social media site that provides when and how and why you would remove comments. And I've listed things out here. This is a statement I think you could just drop right into your social media site as a disclaimer. But clearly, you're not going to be just removing comments because you don't like what they say, but because they fit in this criteria. And here's a continuation of that statement that I recommend be included as a matter of how and when and why you would remove public comments.
Hey, Angela, got a question here.
Sure.
Will the terms of use policy be included within social media policy?
No, I don't think so, because your social media policy is going to be for your employees. So that's something you would see in your handbook. Your internal policy about how you're going to run your social media sites, I think that could also be a component of your social media policy and in your employee handbook, because that's governing employee conduct. But the terms of use that I'm talking about right now with respect to how the social media site function vis-a-vis the public, that's not going to be like a handbook policy type thing. That's something that's going to need to be embedded in your social media site in terms of the approvals to participate in it or disclaimers on your site at some point. Sometimes folks will use it as like a point and click, like here, click here for terms of use. So you've disclosed it. Now, will users typically go there and read it all? It's just like if you've never read it, if you go to Facebook or Twitter, any of those terms of use, they're extensive. And I would venture to say nobody reads that stuff. But it's good to have it, because if something comes up and you remove a user for some reason, then you can go to terms of use and say, look, here's our terms of use. It was disclosed by participating. You agreed to follow these rules. You didn't follow the rules, and therefore we've removed your comments and removed your participation from our site. So this is distinctive in terms of this is how your government social media site is functioning with respect to the public, not with respect to your individual employees. Although your individual employees could also be posting, I guess, on your government site as well. Hope that answers that question. Here's another statement that I would suggest putting in your terms of use, just declaring that you're not going to discriminate based on viewpoint. So you'll have the criteria that says, here's how we remove comments, but then a statement that says, we're not removing comments based upon viewpoint discrimination, because that would be inappropriate under the First Amendment. I think it's important that your terms of use explain how you will go about making a decision about removal of comments. And also, I think it's important if you remove a comment that you document it. So if you decide that you're going to block a user or block some comments, retain the comment, do a screenshot or do whatever you need to do to retain it, along with the description and support for why you removed it. If there's a claim later on, someone contends, a member of the public contends you violated their First Amendment rights because you blocked them or you removed their comments from your site, then you would have the documentary evidence to come back and prove it and would not be worried about whether a technological person could recover that through your social media site. Just go ahead and retain a copy, document the reason, and put that in your file. I think you should notify or consider notifying the person that you have removed from the site. And also you want to provide a mechanism that they can contact the administrator, sort of like an appeal, and I think if you do those things, then you're greatly enhancing your ability to defend against any kind of claim that might come against the government because of any removal of comments. Now, some of this may sound a little much, and maybe you're not having these issues, but I promise you that they're to come, because I think more and more governments are using social media sites and more people are reaching out on these sites as opposed to showing up at these public meetings like people had to do in the past. People, I think, in the public believe they should be able to log on and tell their government what they think. And then when they do, and if it's deemed offensive or somehow contrary to your terms of use policy and you remove it, then that's when you can see these claims. It's almost like if you have a speaker come up at a public hearing and you shut them down because they're saying something inappropriate, they may get worked up over that and make a claim and say their First Amendment rights were violated. We'll take that same kind of scenario that maybe you've seen in your government or certainly could happen, and I've seen it happen in real time, and just translate that into your social media site, and that's the same kind of things that you could see happen there. And so that's why I'm focusing on these issues for you, is because they can give rise to First Amendment claims. Here's another disclosure that I think is important on your social media site. Folks need to understand when they engage with the government, whether it's writing, emailing, posting, Twitter, tweets, anything, that is subject to open records. And they need to follow, not only do they need to follow all laws, but realize that they're going to be subject to production of these as public records as well. All right, now that just kind of tees up this notion of social media user blocking. So if you're blocking users, there's three parts of a test that you really need to consider. Is that particular site a situation where it's a private capacity or official capacity site? Is the social media site a public forum? And then are you talking about viewpoint versus content-based speech? And I'm going to explain these a little bit more in the short time we have left. So the first part of this test is trying to decide if it's a private capacity or an official capacity speech. So we know that the First Amendment, as we've talked about, it prohibits government regulation of private speech. So, but it does not govern private regulation of private speech. So the government can't regulate speech, but private parties can. So that's why we have to decide, is the person who's blocking the speech, is that a private speaker or is it a government speaker? I'm going to give you an example in a minute. I think will make all this make a lot more sense. But if you have a Facebook page, for instance, of your chairman, or a Facebook page of a police chief, is that their private pages such that the government, he's not acting as an official capacity element of the government, or is that an official capacity social media site where if that chairman or if that police chief blocks people, that then they've engaged in First Amendment violations? That's kind of the heart of what we're getting at with this notion of First Amendment violations when blocking users. So if we're found to be acting in an official capacity, whether it's on a private account or a government account, then the First Amendment protections will apply. Now, if you're talking about your just general social media platform, your government, the XYZ county Facebook page, then obviously that's an official capacity, it's a public forum, and if you block somebody, we have to worry about that from a First Amendment context. But again, situations where you might have the chairman has a page, the police chief has a page, maybe your director of planning has a page, then you have to do this little bit more consideration of whether it's official or whether it's individual. If it's an individual account, then they can block people at will, and just like you can block people on your Facebook pages. So that's why we have to ask the question of whether it's private or official capacity. There's not a bright line rule, like none of this has bright line clear rules. It's all mushy in the First Amendment context, unfortunately. But here's some questions that you might ask yourself in terms of whether that is an official page or official platform or not. For instance, if your chairman of your county commission has a Facebook page and the county somehow is administering that or funding it or supporting it, maybe the clerk of the county runs it and posts to it for that chairman. I've seen that happen before as sort of an assistant type situation. Well, then that certainly looks akin to an official account. And in that case, if that chairman blocks someone, we need to worry about that being a government violation of the First Amendment. The second test we're going to look at is whether it's a public forum. What is the context of the social media site? Again, if it's your official county or city website or county or city Facebook page, then it's absolutely a public forum and it will be deemed to be such. Again, I note here the limited public forum distinction. And again, I suggest you put that in your terms of use so people understand they can express themselves, but within certain limits and only on certain topics. The last thing you want to look at is if you're blocking someone and you're the government. Remember, we don't care if you've got your own individual Facebook page and somebody ticks you off because they said they didn't like your dress in that post, block away, no problem. I will tell you, I blocked some people, not so long ago just because I couldn't stand the banter anymore. So you can do that. That's not a First Amendment violation. But if your government social media platform is going to block someone, we got to be careful that it's not based on viewpoint discrimination. We can't do it just because we don't like what they're saying or because they're critical of the government. So ask whether it's viewpoint or whether it's a content-based limitation that would be more appropriate to remove. So by content-based limitations, those restrict the subject matter or topics that can be discussed. So if you have a sheriff's office Facebook page and you see in your terms of use is limited to discussion of sheriff's office matters, and this person starts posting something about, I don't know, a water treatment plant or a landfill, something that's completely unrelated to law enforcement, and the sheriff's office removes that post, I'm much less concerned about that because it's a content-based removal that's not appropriate within that limited forum. However, if we have someone speaking out on the sheriff's page because they don't like the sheriff and that gets removed, then that would be a problem from a First Amendment context. All right, here's the case that I think will make all of that make sense, and this is where I'm going to start wrapping up real soon. There was a case with President Trump. And as many of us, and if not all of us know, President Trump likes to tweet, and he used Twitter a lot during his presidency. So what you may not know is that there was a lawsuit that had to do with his use of Twitter. So President Trump, ultimately removed some users who were engaging on his Twitter in a very offensive and negative way. President Trump, when sued by these users who had gotten blocked, they contended that he had violated their First Amendment rights, and they brought a lawsuit. So the court went through the test that we just talked about and tried to decide, okay, is President Trump acting in his official capacity when he's tweeting, or is it in his individual and personal capacity? Well, this particular court, it was in the Second Circuit, decided he was tweeting in his official capacity. Okay, so then we go to step 2, and they decided that President Trump's Twitter was deemed to be a public forum, meaning that that's a place where there should be a free discourse of speech. So after deciding that the Twitter was official capacity and a public forum, then the court ruled that President Trump's removal of those users resulted in a First Amendment violation because he blocked them in their ability to engage with him in his speech in violation of the First Amendment rights. So that is an individual, like I gave an example of a chairman or a sheriff or a police chief. That's the president. So, but an example of blocking potential users. Again, if it's your county or city social media platform and you're blocking users or comments, then I think you don't even have to really ask the questions, is it official capacity or is it a social, public forum platform, because it's just going to be, it's clearly is. So when you are engaging in blocking comments or blocking users, then you really do have to worry about First Amendment. And I would be very constrained, honestly, if you're going to consider doing that. I've had people ask me, there's always activists in every community. I've got many calls about, they're just stirring up trouble and there's all these comments and it's wrong and it's untrue. And, they can be subject to defamation, and that's not our issue. Someone can sue them for defamation. But if they are commenting in a manner on the public county or city Facebook page, and it's not something that's within our criteria for removal because it's profane or offensive in a way that reaches that criteria, then I just tell clients you really need to just let it go, because the notion of violating First Amendment freedoms, that becomes a huge issue of liability. And also then it's a big, media blitz. That's your front page news story, as opposed to just kind of ignoring some of these nuisance comments. But in this instance, again, I want to talk to you a little bit more about this case. So in this Trump case, ultimately got up to the United States Supreme Court. The court remanded it back to the Second Circuit and vacated it. Means basically made the case go away, because at the point that it reached the Supreme Court, Biden had taken over and they deemed it to be a moot issue. But in this case by the Supreme Court, there was a very interesting concurring opinion by Justice Clarence Thomas that I just wanted to share with you, because again, this sort of brings us full circle to the to the concept of how significant social media is in our world and in our workplace today. And here's what Justice Thomas said when he concurred in vacating this case of President Trump. He said this: President Trump blocked several people from interacting with his messages. Twitter barred Mr. Trump not only from interacting with a few users, but removed him from the entire platform, which caused his Twitter users to not be able to interact with his messages. Justice Thomas said, it seems rather odd to say that something is a government forum when a private company has unrestricted authority to do away with it. So that could apply in our situations as well. When we're using Instagram or Twitter or Facebook, it's going to be deemed a government forum. I'm confident of that, but it's an odd thing to suggest it's a government forum that we really have no control over, because it could be shut down at any time by these private companies who run the platforms. So this is the point I wanted you to take away from this. Justice Thomas said this: today's digital platform provides avenues for historically unprecedented amounts of speech, including speech by government actors. Also unprecedented, however, is the concentrated control of so much speech in the hands of a few private parties. We will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure such as digital platforms. And I just found that as an interesting book into this case and really our conversation today, because it demonstrates that social media has become so prevalent and so widespread, although it's owned by just a few individuals, that it really is the ultimate First Amendment forum. And so we have to be very careful when we're dealing with our social media policies vis-a-vis our employees, when we're dealing with our social media platforms vis-a-vis the public, because it really is going to garner the fullest panoply of First Amendment protections. And I think increasingly, as Justice Thomas said, we're going to see courts having to struggle more and more with how to deal with the First Amendment constraints and First Amendment freedoms. And so we want to make sure that that's always in the forefront of our minds when dealing with any of these social media issues. The last point I want to raise with you, while we've talked about the First Amendment, please don't forget that there's also an opportunity to engage in discrimination under Title VII or equal protection when you're deciding how to enforce your social media policies. So I mentioned earlier that, you know, you get a complaint and someone's posted something, and so you discipline Tom. That's fine. Complaint came to you and you disciplined him. If you don't know that John did the same thing, then not discipline John is okay, because you're not charged as an employer to survey everybody's social media accounts and to monitor them. Of course, you're not required to do that. You couldn't do that, nor would you want to do that. But if you discipline Tom and you happen to get a complaint as well about John and you don't discipline John, then that could give rise to a Title VII or an equal protection claim. So the point is here, be fair, be consistent in how you do that in terms of any disciplinary action. And it's important, if you've got a social media policy, that's the first step, and then you apply it equally and consistently. And that can be harder than it sounds to apply it consistently because there's very many levels of variation in these issues and case-by-case considerations, but try to be consistent with how you approach these issues. And then remember also fairness and consistency when you're talking about blocking users. If you block users and it's a legitimate block because they're violating your terms of use, they're within the criteria of removal of comments because they've really just overstepped some of the levels of appropriateness, then that's okay, but make sure that you do that with respect to all users and not just one or two users that maybe have gotten under your skin because of other issues or other posts and comments. So summing it all up really quickly, because we just always run out of time, I apologize for that. You know, First Amendment is king when it comes to social media. Just as Clarence Thomas has noted, these social media sites now are really the town square. It's where our town criers are putting out their information. We have to be careful that while we want to maintain appropriate decorum in the workplace and make sure you protect the integrity and reputation of your government, that you do it in a manner through good, strong policies that allow you to discipline employees when it's appropriate, but also to do it within the confines of their First Amendment interests to use this social media platform for free speech. Also, having that social media policy with the 3 rules of engagement is kind of your overriding governance. I think that's important. That can give you a solid foundation for these disciplinary matters. And then finally, it's just easy to think you create a Facebook page, you create an Instagram, but I would venture to say many governments have not really thought long and hard about the internal use controls that you need to have in terms of a policy. Who's got the authority to post? How's that being done? And then maybe just as importantly or more importantly, what your terms of use are for how you're going to use that social media platform and control it and maintain and manage it vis-a-vis the public. Those are all issues that I hope I've made you think about today. Maybe some things you haven't been confronted with yet, but are sure to come in the future as social media just continues to permeate and dominate our society. So I feel like I've been speed talking, but hopefully that's a lot of information for you to consider. Dan's going to send out the PowerPoint, so you'll have these lists of policies that I hope will be helpful to you as you look through your policy as a checklist. And then happy to answer any questions if anyone has any questions right now, or you can follow up with me later if you like.
Angela, one question that was a while back and I didn't pop in, but if the purpose of the site is stated as not a public forum for information only, is that enough to hide a comment?
Well, I don't think you can proclaim yourself to be not a public forum. I think you can claim a limited public forum, but as a government, there's just no way you're going to be able to say this is purely private because you are you're a government actor. So I think the best you can do is that disclaimer that I included in the materials as to a limited public forum, which means that you're going to have use rules and controls that can be removed or hidden for certain comments that fall within that criteria. But again, I always say exercise caution on that because, you know, it can be a dicey thing. And you know, not only do you have to worry about, okay, that individual who might bring that claim, but you certainly don't want to have a reputation in the community that when the government doesn't like what we say, we get censored or we get muted. So it's, you know, can create bigger issues outside of that one user. But I think you have to face the fact that you're going to be a public forum, try to make it and proclaim it as a limited public forum with your terms of use and your rules, but you're not going to be able to be deemed purely private just by virtue of the government.
Another comment, this is great information, but had a few interruptions. Will the recording be shared? Yes, I'll be sending a link with the recording and you can watch it over and over and over again, which I'm sure people will do. Along with the, we'll also send the presentation. Question, is it possible to provide at least a boilerplate social media policy? We have one and I'll actually share that with you. You can, I'm not sure if it exactly aligns with what Angela has said, but I think that her presentation can be used to help with that. Any comments on that, Angela?
Well, and I'm not sure what policy you have, and I figured this question would come up. So I have not written from scratch a social media policy in a good long while. You know, I have looked at policies for clients and tweaked them, and then through the case law kind of come up with these points that I think are good. And so I have not produced a policy that I'm going to put out that I think is the be all end all perfect policy. You know, I'm happy to share some that I think are legal. I think the challenge when you get into it is everybody approaches things a little bit differently in terms of how they want to control it, what their messaging is, because it's a very personal message in some respects as to how you want to tell your employees you're going to govern what's essentially their off-duty conduct. And also depending on what social media platforms you have and how you internally intend to control those. Those are all very fact specific. So I find it kind of hard to have a one size fits all policy. But be happy to look at Dan's and you know, if anyone wants to reach out to me, happy to share some that I think are legal. It may just be that it's not the best fit for you. But I do think if you take the policy provisions that I have there and either line them up with your policy or use them as, you know, a checkpoint to just drop into a new policy, that you have the makings of everything you need to cover there.
Very good, very good. Again, lots of great comments. So much great information. Thanks. Can a comment be blocked because of using cursing or discriminating terms alone, regardless of the opinion stated?
Absolutely. I mean, I think that's kind of your quintessential opportunity to block. Again, if you have on your terms of use, or you know, even if you don't want to get real fancy with the terms of use, if you just want to have a disclaimer, you know, somewhere on your Facebook or your Instagram page that says, you know, we will not tolerate these types of comments. You know, many times you have those same kinds of rules of procedure for your public meetings. It's the same kind of thing. You're not going to allow people to curse. You're not going to allow people to disparage. You're not going to allow people to discriminate. Those are the quintessential things that I'm very comfortable removing. Sometimes the questions and the comments are a little more gray, but if there's profanity and there's discriminatory comments, I think that's easy, that you can remove those without trouble.
One last question. If employee has employment name in Facebook profile that would still be considered that person views as public employee?
So that's a great question because, you know, I'm not a Facebook expert by any stretch, but in your profile, typically it will ask you where you employed. And so that may be a very innocent, you know, issue that employees aren't really intending to hold themselves out as a member of your government, but they just filled in the blank when Facebook said, you know, where do you work? Often that will pop up too, to my recollection and understanding, that you will see that when someone asks you to be a friend. I mean, it's one of those things that is not hidden, I guess is what I'm trying to say, that it's very, very visible. You know, I have not had an issue ever come up where someone is seeking to discipline an employee because they listed their workplace. So I'm not sure I would suggest that be your rule, that you can't indicate on Facebook where you work. I think you could discourage it. You could certainly say, where you employed, local government, without identifying where and who. The reality is that many times on a Facebook page, if it has some private controls, these people are your quote unquote friends. So they probably already know where you work, to be honest. What I think you want to be more concerned about is if they're posting in uniforms and, with, in posting as to issues that implicate directly their job functions. I think that's more concerning from a disciplinary matter. I'm not sure I would go out trying to canvass everybody's Facebook page, and discipline people for just listing who their employer is. But ideally, they wouldn't. So I think you could put in your policy that there's a preference for listing a generic employer as opposed to a specific employer.
Here's another question. Where do you suggest the terms of use be located?
Again, I'm not a technical guru, but I think many times those are embedded like through a link. Like I don't go on many county Facebook pages, or even when you go on your Facebook page or on your Instagram page, it's hard to find those terms of use. You have to kind of dig into it a little bit. So I think somewhere that may be a better question for your technical person in terms of how you would embed those in a link. I don't think you necessarily, want them to be front and center, understandably, because you want your Facebook page to be inviting. You probably got pictures of your community and you want it to be, sort of a marketing piece, so to speak. So you're not going to want a bunch of legal boilerplate up front, but maybe on that front page that there's some link at the bottom that you could click into and have those terms of use. That's the way I think people do it. But again, I would consult with your IT folks on where best to embed that. But I'm not suggesting it needs to be up front where everybody sees that before they see anything else on your page. It's really sort of a safeguard so that if you get a legal claim, we can say, look, it was right here. Because you know how it is. Whenever you access anybody's site anywhere, sometimes you have to check off that you agree to terms of use, sometimes you don't. But you're going to be deemed to acquiesce to those terms of use if you engage and participate. So it's a safeguard that we could argue later. If we block a user and we get a First Amendment claim, we can say, look, by participating and interacting on our page, they agreed to the terms of use, and here's what the terms of use say about inappropriate comments. So it doesn't have to be front and center, it just has to be there so that we could rely on it if we needed to as a defense.
Other comments? Great presentation. So again, thank you so much. 100% of the comments are great presentation.
And that's statistical data, right?
That's statistical data. So with that being said, I'll let you go, Angela. Thank you so much. Thank all of you for participating. And if you have any questions or thoughts in the future, don't hesitate to reach out to us or me, and I'll be happy to do what I can to help you out. Again, thank you so much to everyone. Stay safe, stay healthy, and we will talk to you later.
Thanks. Everybody have a great day. Thank you. Thanks, Ann.
Thank you.